Objection, Judge. Mr. Oginski's medical expert should not be allowed to testify because his opinions are not in accordance with the majority of other doctors in this specialty. You want to know what this is all about? Come join me for a moment as I share with you some remarkable information about something that goes on during medical malpractice trials all the time. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury trial lawyer practicing law here in the state of New York. During the course of a trial, we are required, as the attorney who represents the injured victim, to put on medical experts to support our claim. Now, what happens if the medical expert that I put on to testify is not in the majority opinion of what other doctors would consider to be appropriate? And now our doctor believes and comes to the conclusions that are totally different than the majority of other doctors in the same specialty. Can my expert still testify? The answer is yes, he can. Just because a doctor comes to different conclusions than the majority of other doctors in that same specialty, it doesn't mean he's wrong. It means he's simply in the minority. And the mere fact that the doctor is in minority does not prohibit him from testifying. Instead, what will happen is the judge will allow the witness to testify, assuming, of course, he's credentialed, and I'll tell you more about that in a minute, and then it will ultimately be up to the jury to determine whether or not we have shown that we are more likely right than wrong, that a doctor violated the basic standards of medical care, and those violations were a cause of your significant injuries. So now, let me go back to the qualifications issue. When we bring in a medical expert, we are trying to bring in somebody who's well qualified in this particular specialty. And in every medical malpractice case in New York, what happens is the plaintiff, we bring in our medical experts, the defense will bring in their medical experts, and what do you think happens? You have two diametrically opposed opinions, two conclusions that are totally different, looking at the same exact set of facts. And you may be wondering, how is that physically possible? Well, the reality is, jurors don't have to sit there for weeks and weeks on end trying to determine whether we are 100% correct and 100% certain that what we are claiming is true. Instead, they only have to determine that we are more likely right than wrong. Can a doctor who does not have a majority opinion consistent with lots of other doctors in the community, can he still give testimony in a medical malpractice case in New York? The answer is yes, he can. And you want to know why? Here's a critical point. It's because his testimony may confirm that the majority thinking is wrong. That's why the judge allows that type of witness to testify. So why do I share this great information with you? I share it with you to give you an insight and an understanding into what goes on in a medical malpractice trial here in the state of New York. You know, chances are you're watching this because you likely have questions or concerns about your own particular matter. Well, if your matter did happen here in New York and you do have legal questions, what I encourage you to do is pick up the phone and call me. I can answer your legal questions. You know, this is something I do every single day and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at oginski-law.com. That's it for today's quick video. I'm Gerry Oginski. Have a great day.